Hi, I'm Trip Stroud, founder and attorney here at Valley View Law, based in beautiful Spring Green, Wisconsin. We're a criminal defense firm. We represent folks that live in rural communities and small towns here in southwest Wisconsin who have been accused of committing a crime. That's all we do every day, all day. Um, Today, I'm here to talk about domestic incidents. If you live out here in rural Wisconsin, you know it's something that happens. It's a fact of life and love that people that are close to each other get in arguments. Sometimes they can get pretty heated, they can get out of hand, or maybe even get violent. And when they get violent or they get out of hand, law enforcement gets called to intervene. And almost all the time, someone gets arrested when that happens. And if you're finding yourself in that situation, then this video is for you. So let's say that you've been arrested for a domestic incident. One thing that you might be wondering, and certainly many people wonder this if they've been arrested, is why was it me? Why did I get arrested and not my boyfriend or girlfriend who was doing just the same thing as me or worse? Um, it's a fair question, and to do my best to answer that, law enforcement, when they get called to a domestic incident, they have a duty to arrest the person that's the predominant aggressor. Okay, and what we call that is a mandatory arrest, and the predominant aggressor um, is a snap decision that law enforcement needs to make when they arrive at the scene. How do they make that decision? They're law enforcement, they're human, they're not perfect. They don't get all the information or they make mistakes, but they do their best to find out by taking statements from all the parties involved in the incident. They take statements from everybody else that might have witnessed it, the person who might have called it in to begin with. They'll look to see, does anyone have any obvious injuries like scratches or bruises or bloody lip, that sort of thing. They'll look to see, is anybody intoxicated? Has anybody obviously been drinking? Does anyone have any open cases like that relate to a past domestic incident? Is anyone under a restraining order, a bond condition that says you can't be around each other? Those are the kinds of things that law enforcement is going to look at and rely on to make a decision. All right, who's the predominant aggressor here? Who's the highest risk that we need to separate from the situation and remove? And a lot of times that's the predominant aggressor is the one who called 911 in the first place, the one who called for help. It doesn't mean that it's right. It doesn't mean that you're a bad person if you got arrested. It doesn't mean that the person who did get arrested is good or innocent. It just means that you got caught at the wrong time, and law enforcement made a snap judgment and decided that you were the predominant aggressor. If you hired an attorney who is familiar with and comfortable with the domestic abuse environment, there's ways that you can dig yourself out of that and take that label off of yourself and either cast it aside or make sure that the spotlight gets put on somebody else. So hiring someone who's experienced in these kinds of cases can be very helpful to you to shift the spotlight off of you. Another thing that folks encounter, some that can be confusing if they've been arrested for a domestic incident, is the concept of no contact orders. Now, what's a no contact order? Generally, what it means is no contact means someone is protected by this order. This person, whether that's your boyfriend or girlfriend or husband or wife, whatever, the person who's protected, you can't contact them, obviously, but you can't go to their residence. You can't go to their work. No, you can't call them. You can't text them. No social media messages. You basically have to go to your separate corners until that no contact order doesn't apply anymore. And an area where people get confused is that there's multiple different kinds of no contact orders that can be put in place in a domestic incident. The first is, and the most immediate one, is a no contact order that's imposed by law enforcement. Law enforcement has the power to impose a 72-hour no contact order that, against, let's say you're the person who's a predominant aggressor, the no contact order prohibits you from contacting the person who's protected by it for 72 hours. The person who's protected by that order, they can tell law enforcement at the time, they can say, I want contact. I'm not going to sign up for this no contact order. Just let it be. Okay. Let Jim or Jane or whatever the case may be, let them stay home, or I want them to come back home. But let's say that it's not waived and the 72-hour no contact order stays in place. Then that means you've got to keep your distance for the next 72 hours until it expires. And then you can come home. Where folks get confused is that once that no contact order is no longer in place because it's been waived or because it's expired, the court will impose another one as part of your bond. Now, what bond means is bond is just a fancy legal word of the conditions of your release from jail while your criminal case is pending. So one of those conditions might be you have to put up cash, or you have to guarantee that you'll pay the court if you don't show up to your court date. That's a type of bond condition. Another is that you won't have contact with the quote unquote victim in your case. Unlike the 72-hour no contact order, the court imposed bond condition, no contact as a part of your bond, does not expire until your case is over or until the judge says it's different. And unlike the 72-hour no contact order, it can't be waived. So even if your boyfriend or girlfriend or whatever the case may be says they want contact and and it's okay for you to come home, it's okay for you to be around them, that's not enough. You need to have the court say, okay, you can have contact again. And your best bet to get in that position is to hire an attorney that knows their way around these domestic incidents, that knows what a court wants to hear or see before they'll lift a no contact order as a condition of your bond. Where people get confused is that they'll say, well, hey, I thought you waived it, or I thought it was expired after 72 hours, or no, that's wrong. That's wrong. You have to, the only way you can change a no contact order that's a condition of your bond is if a judge says so. All right. Another thing that people get confused by is, as it relates to no contact orders, is, well, it says here that I can't have contact with my boyfriend or girlfriend, whatever the case may be, or their residence. Well, that's my residence too. And actually, it's my house. I'm the only one on the deed, or I'm the only one on the lease, and I'm paying all the bills. What do you mean I can't go there? A lot of people will answer that question for themselves and say, well, there's no way that the court's telling me I can't live in my own house. So they go ahead and move back in, pretend like everything's normal. And that's where you get into trouble, because that is the incorrect interpretation. It's very important that you understand the conditions of your bond, and a criminal defense attorney can help you with this. But if no contact means no contact. So if you have a no contact order in place that says you can't even go into your own house, you need an attorney to help you get that condition lifted. And a skilled criminal defense attorney will be able to get you in a position to do that. That's all there is for now. There's a whole lot more. And if you have any questions because you find yourself in one of these situations where you're accused of domestic abuse in some way, shape, or form, I strongly encourage you to get in touch with a lawyer, but I'd love to hear from you here at Valley View Law. If you have any questions, you can call us at 608-588-0585, or please visit our website at www.valleyviewlaw.com. Thanks, and have a great day.